Good day, Crime Talk aficionados. This is Crime Talk. We have a great show for you today. First, the defense did nothing wrong in their survey in the Bryan Kohberger case, and they may continue. Will a jury hear Richard Allen's alleged confessions? The George Kelly case results in a mistrial. The prosecution should now dismiss. Would you trust this guy around your kids? I don't think so. And simple rules for life to know. If you kill your spouse to avoid divorce, you're going to go to prison for the rest of your life. And then our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and remember, you can check us out on any of your favorite podcasting apps. All right, before we get to the docket today, quick reminder, since it's Tuesday, that means we'll be going live 6 p.m. Mountain Time. Obviously, we have a lot to talk about. Had a great show last week. Please join us tonight, 6 p.m. Mountain Time. All right, let's go ahead and open the record for April 23rd, 2024. And first on the docket, that's right, the lawyers for Bryan Kohberger, you know, the guy accused of stabbing to death 4 Idaho college students back in 2022, they can now continue their survey of prospective jurors in the state. And the judge overseeing the case has ruled that way. Now, Kohberger's lawyers, as you may recall, had hired a consultant to conduct community phone polling ahead of the upcoming capital murder trial in order to gauge the attitude and potential bias of people who could potentially sit on the jury for Bryan Kohberger. Well, that survey, which had become a source of some pretrial contention, as you may recall, I think I called the prosecutor petty and at the hearing unprepared. Well, the defense can now proceed without changing a single question, including the 9 which the prosecutors have taken great issue with. And the defense may continue its survey without modification to the survey. Now, since we like to be thorough, accurate, I think it's better, instead of me just giving you that quick summary, let's just go straight to the order, ladies and gentlemen. And because, well, there's a little bit of humility in this order from the judge, kind of realizing perhaps the errors of his ways. But that's what happens when you sign orders without getting a response from the other side, kind of violating the whole tenets of the legal system. The prosecution files a motion, the defense responds, let's set it for a hearing. We didn't really get that, and everybody overreacted. I thought that everybody overreacted a little bit. I had people telling me, Scott, they're tainting the jury, you're terrible, they're tainting these potential jurors. Listen, if you really think this trial is going to take place in Moscow, Idaho, it's not, okay? So we should probably just get used to that. So anyway, here's the order from the judge. On March 22nd, 2024, the state filed a sealed motion for an order prohibiting further contact with prospective jurors absent leave of the court. The same day, defendant Bryan Kohberger filed an objection to the state's motion with the promise of a forthcoming affidavit and memorandum in support of the objection. The court then entered a temporary order prohibiting both parties from contacting potential jurors about this case, included via third parties, until further order of the court. A hearing on this issue was set for April 4th of 2024. In the interim, the defense filed a memorandum in support of objection to the state's motion for order prohibiting contact with prospective jurors absent leave of the court, with the declaration of Brian Edelman, Ph.D., attached, and a motion to rescind order for failure to provide due process. On March 29th, 2024, the state filed a declaration in response to the defendant's motion to rescind order for failure to provide due process, a reply in support of the motion for order prohibiting contact with prospective jurors absent leave of the court, and an objection of defendant's motion to rescind order for failure to provide due process. Don't you love how we always got to rehash everything? I get it, but that's the way it is to be thorough in the legal writing. Then on March 29th, the defense filed a reply in support of the motion to rescind an order for failure to due process, On April 4th, 2024, a hearing was in open court and to the public because neither party requested that the hearing be sealed. At the time, the court heard argument from both parties regarding a survey the defense had conducted in Latah County and wished to conduct in 2 additional counties. The state took issue with 9 of the questions in the survey, which were read into the record in open court, and argued that asking those specific questions to potential jurors violated the court's revised amended non-dissemination order entered on June 23, 2023. Specifically, the non-dissemination order prevents the attorneys in this case or their agents from making out-of-court statements which a reasonable person would expect to be disseminated by means of public communication and that relate to the following. 1, the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings, and 2, any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence in the trial, and that would, if disclosed, create a substantial of prejudicing an impartial jury. The state asserted the question violated these provisions because the surveyors and are agents of the defense, and the defense bears the responsibility to honor the non-dissemination order. The defense argued that the questions in the survey were based on information obtained by defense expert Bryan Kohberger from reading and watching various news articles and broadcasts from both mainstream media and social media. The defense further argued that the question did not violate the non-dissemination order because they constituted information contained in the public record. The defense argued that the public record encompasses all information in the media for the public's consumption. The non-dissemination order expressly allows attorneys involved in this case and their agents to make extrajudicial statements, written or oral, concerning information contained in the public record. At the conclusion of the hearing, the court ruled that the defendant's due process rights had not been violated because 1, the order to pause the survey was entered after defendant filed an objection to such order, and the order was temporary, and the defendant was given notice and the opportunity to be heard at the hearing set shortly after the temporary order was filed. Now, technically, the judge filed it. The defense said, hey, this is filed on a Friday afternoon. The judge has already granted it, but here's my objection, just so the record's clear. Anyway, the Due Process Clause of the 14th Amendment to the United States Constitution provides that no state shall deprive any person of life, liberty, or property without due process of law. The right to procedural due process guaranteed under both the Idaho and the United States Constitution requires that a person involved in the judicial process be given meaningful notice and a meaningful opportunity to be heard. Due process requires that judicial proceedings be fundamentally fair. Procedural due process is not a rigid concept, but rather it is flexible and calls for such procedural protections as the particular situation demands. And he cites a case. The court also kept the temporary order prohibiting contact with potential jurors in place and instructed defense counsel to consult with Bryan Kohberger to determine if there was a way to the survey would continue while eliminating the concerning questions the state raised. The hearing was scheduled to continue April 10th, 2024. On April 10th, 2024, the parties again reconvened in open court. Again, neither party requested that the hearing be sealed. The question at issue were again discussed, including the fact that some of the questions on the survey are not rooted in fact or supported by admissible evidence, but are simply rumors in the media and on social media, while other questions were formulated based upon information from the public probable cause affidavit filed by the state. Now, after a lengthy hearing, the parties remained at odds over whether the 9 questions at issues should be allowed to be asked in the survey conducted by the defense in other counties. The court now orders the following. First, the public record, as the term is used in the non-dissemination order, means the public record, i.e., information from public hearings and from documents filed in the case that are not sealed. 2, information that formed the basis for 6 of the 9 questions at issue came from the probable cause affidavit, a document filed in this case that is not sealed. The non-dissemination order expressly allows attorneys involved in this case and their agents to make extrajudicial statements, written or oral, concerning information contained in the public record. Additionally, One of the questions was not based on admissible or inadmissible evidence, but instead asked about the feelings of members of the Moscow community. Therefore, the defense did not violate the non-dissemination order by asking 7 of the 9 questions. As to the remaining 2 questions, prior to the hearing, there was not information contained in the public record about these media items. However, these questions have now been read into the public record and discussed at length during the hearing, including the fact that these media items may not be true. Because the information is now in the public record, the court does not see any benefit in preventing the defense from continuing its survey or requiring that the 2 questions at issue be eliminated. Again, these questions and media items are now part of the public record, and the non-dissemination order does not prohibit attorneys involved in this case or their agents from making extrajudicial statements about information contained in the public record. The non-dissemination order allows extrajudicial statements that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of the recent publicity not initiated by the lawyer or the lawyer's client. Any such statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. Defense counsel argued at length that the 2 media items not contained in the public record were the subject of extensive media coverage, and that was prejudicial to the defendant, and that the survey question asking potential jurors if they had read, seen, or heard of these media items was necessary to support defendant's motion for change of venue, which aimed at mitigating the effects of prejudicial pretrial publicity on the defendant's right to a fair trial. The goal of the non-dissemination order is to ensure a fair and impartial jury can be impaneled so that defendant receives a fair trial. If defense counsel believes asking these survey questions, which arguably contain prejudicial information or misinformation about the defendant, is more beneficial than harmful, as defendant expert testified, the court does not at this juncture have sufficient information or evidence to second-guess that strategic decision by trial counsel. The court's order prohibiting contact with prospective jurors until further order of the court is lifted, and the defense may continue its survey without modification to the survey questions. Any extrajudicial statements by an attorney involved in this case or their agent must continue to comply with the non-dissemination order. So, I read between the lines there a little humility by Judge. And you say, well, Scott, he's basically saying, well, if the defense wants to ask these questions, they certainly can. Well, of course the defense wants to ask those questions because that information, the false information, based upon speculation, innuendo, and rumor, has been put out there by the mainstream media press as well as online. So they have to see how that has affected the people. I mean, to say that you can only talk about what's in the public record, but you can't talk about what's in the news media, it made no sense to me at the time. I think the judge came around and said, yeah, I guess that really doesn't make a whole lot of sense. And, oh, Mr. Prosecutor, you're the one that read these questions into the record. You didn't ask for this to be sealed. So kind of a pox on both your houses, so to speak. But the reality of it is the defense did nothing wrong. Now, like I said, I took so much heat. And I don't want to say I told you so. But I was just like, they're asking information that was in the public domain to see if people thought that was true and that it affected their ability to be fair and impartial. There you go. Why wouldn't you be able to ask that question? I really think the judge had never dealt with this particular issue as it related to surveys, particularly in a high-profile case like this. And frankly, neither had the prosecution. And the prosecution showed up completely and utterly unprepared for the hearing. And basically, there's no evidence to refute Dr. Edelman's position that you have to ask these questions in the survey. So that's what happens when you don't show up prepared for court. You lose. And it kind of makes you look a little petty. But that's just me. So at least I got that off my chest. All right, next. Richard Allen will his alleged confessions be heard by the jury? Well, the prosecutor in the Delphi murder case is arguing against a defense motion to suppress Richard Allen's alleged confessions to the murder of Abby Williams and Libby German made while he was in prison awaiting trial. Now, the state is expected to use Allen's jailhouse statements against him, but the defense team says the comments Allen allegedly said don't match up with the evidence from the crime scene and therefore show that the confession cannot be true. Now, attorneys for Allen asked Judge Francis C. Gull to suppress any statements Allen made while he's been in prison awaiting trial, claiming that the incriminating comments were not made voluntarily and came while he was mentally ill. For these reasons, Allen's public defenders say allowing a jury to hear the alleged confessions would violate the defendant's constitutional rights. Now, Allen has been housed at a maximum security state prison for nearly 18 months since his arrest back in October of 2022, and he's been charged with killing the two Delphi teenagers whose bodies were found near the Monon High Bridge back in Delphi in February of 2017. Now, in the motion to suppress, filed on April 11th with the court, defense attorneys said Allen had been accused of making incriminating statements to both inmates and guards while he was at the Wabash Correctional Facility between March and June of last year. Defense attorneys allege prison officials posted inmates at Allen's cell door and required those inmates to keep logs of all of Allen's actions and statements and behaviors. And the attorneys say that some of those inmates actively asked Allen questions. Now, the defense team says that essentially amounts to sustained form of interrogation, one that lasted more than 5 months before he was finally broken. Now, the prosecution argues in their response that there were Indiana Department of Corrections staff and inmates referred to as suicide companions who monitored Allen's behavior and statements. The prosecution states that they were assigned to Allen at a frequency determined necessary by mental health personnel. Those monitoring him kept door sheets which log Allen's statements and behaviors. They said inmates were later removed and replaced by staff as suicide companions as Allen had legal documents from the case provided to him, and so it was determined staff should be assigned because of the gag order in the case. In a separate brief filed by the defense, they argue that allowing a jury to hear Allen's statements would be a violation of his constitutional rights because Allen did not have an attorney present when the comments were made. Now, the prosecution responded to that claim, arguing Allen's comments were voluntarily given and that the defense says that Allen suffered from mental health disorder while in prison, made worse by him being placed in isolation. Allen also states that they slipped into a state of psychosis plagued by grossly disorganized, delusional, paranoid, and highly dysfunctional behavior. The defense attorneys argue that behavior detailed in the defense memorandum for the judge includes periods of not sleeping for days, paranoia, stripping off his clothes, drinking toilet water, covering himself with and eating his own feces, and many other socially unacceptable behaviors. The defense team claims that Allen's statements and alleged confessions were not given voluntarily, but as a result of Allen's being overcome by the harsh environment in the prison isolation cell while on suicide watch. And they say any confessions were therefore coerced and should not be admissible to trial. The prosecution says, hey, there was no interrogation of Allen in custody, as the officers were not making statements or taking actions. They would likely elicit an incriminating response. The state agreed it should have to prove Allen's statements were not part of an interrogation, but that the defense calling for all of his statements while in custody to be tossed just isn't sound legal reasoning. The prosecution asked for the defense to argue which of Allen's comments should be suppressed to allow the prosecution to argue the circumstances around the comments to prove that they were legal. Now, the trial is scheduled to begin in May, so obviously the court has a lot of work to do on this one. Now, listen, Allen was put into a prison where people usually go after they're convicted for his safety. The question then becomes, was this part of some sort of tactic to break Allen down? I don't think we have any evidence of that. Posting people to monitor somebody on suicide watch completely reasonable. Yes, those people are government agents, and if whether it was a prison inmate who was assigned to that started asking him questions like, hey man, what did you do? Did you really kill those girls? Yeah, I killed those girls. Then that would be a questioning by a government agent because they were asked to do so by the government. And it was looking for an incriminating response. However, if they're simply just note takers and saying the guy's babbling about killing himself, well, then there's no interrogation taking place by a government agent. I think the defense, they're doing what they have to do, and it helps flush out what statements the prosecutor is going to deem reliable. I believe the court will probably deny these motions, and in this case, the judge, I believe, is correct. These statements will come in, and both the prosecution and the defense will have an opportunity to explain and under what circumstances these statements were made. The defense has already brought in some expert testimony in their motions that basically says he was suffering some psychosis. Well, that's for the jury to decide. And normally there's an instruction given if there's a question as it relates to confessions that the jury can consider the kind of the time, content, and circumstances, how the statements were made and under those particular circumstances. So, yes, I think the alleged statements will be coming in at trial. And if the judge were to grant this motion for the defense, I would be shocked. But I think that she's right on this one. So for all those who say that, oh, Scott, you're so biased, no, we just call it the way we see it. Sometimes the defense has good arguments, sometimes not so good. I get the defense is doing what they got to do, but the reality of it is I think they're coming in. Next, a mistrial in the George Kelly case. That's right, the Arizona rancher received a mistrial after he was accused of shooting a Mexican migrant on his land because only one of the jurors believed that he was guilty. Now, George Kelly, who's 75, ladies and gentlemen, just remember that, was accused of killing this Mexican national on January 30th, 2023 at his home in Nogales near the Mexican border. Now, his defense attorney said that only one juror wanted to convict and the 7 other jurors wanted to acquit. So that one lone holdout caused the mistrial. And like I said, it was 7-1 for acquittal. So the question then becomes, what happens now? The prosecution needs to take a serious look at their case and say, hey, we had 8 jurors, 7 were not guilty. We had one lone holdout that caused a mistrial. This trial went on for a month. Do we do it again? I'm sure the prosecutors have talked to the jury to see whether they thought that their theory of prosecution was correct. Did Kelly kill this Mexican national? Or we just can't tell, and that's reasonable doubt. If that's the case, hopefully the prosecutors will do the ethically right thing to do, which is to not go forward on a case that they don't believe that they can prove beyond a reasonable doubt. And I think when a jury says 7-1 for not guilty, prosecutors have to look at their ethical responsibilities at this point. Can the prosecutors go forward? Yes, they may say, we had 7 rogue jurors and they didn't listen to the evidence and the only one person voting for guilty got it right. They could think that, but they still have that ethical obligation. Remember, prosecutors can't take a case to trial if they don't ethically believe that they could prove the case beyond a reasonable doubt. I think that is in doubt at this point. Needless to say, if the prosecution goes forward, yes, there will be a retrial. How does that affect the defense? Well, usually the defense has that one opportunity to present their evidence. Now, most of it was expert testimony, so it's not going to be a great surprise as to what's coming round 2, but the prosecution always gets to fix their case the second time around. I can just tell you the percentage of victory on a retrial goes down, crashes and burns on the second time around because the prosecution usually fixes their case. All right. If you aren't familiar with this case, prosecutors allege that Mr. Kelly recklessly fired 9 shots from an AK-47 rifle towards a group of men about 100 yards away on his cattle ranch. Kelly had said that he fired warning shots in the air, but he didn't shoot at anyone directly. Kelly was also charged with the aggravated assault against another person in the group, including a man from Honduras who was living in Mexico and who testified during the trial that he had gone into the U.S. that day seeking work. So a status hearing is set for next Monday afternoon when the prosecution will let the court know and Mr. Kelly whether they plan to proceed on the case. Next on the docket, would you want this guy hanging out with your kids? Please meet Solomon Galligan. He was caught on camera walking onto a field at a Black Forest, Colorado elementary school in Aurora, Colorado around 2:20 yesterday afternoon. Now, in the surveillance footage, Galligan is seen walking up to the children in the field before running away from him after he tried grabbing the kids. Now, when Galligan stumbled over a white blanket he was carrying, the children managed to escape. And per the arrest affidavit, he stood up and proceeded towards the young kids again. Witnesses informed police that the children were yelling, "Stranger danger," to alert adults that were unaware that the person was on the school grounds. Now, Mr. Galligan stopped what he was doing, left the vicinity, and then departed the school. Now, according to the affidavit for arrest, the children say that the man pursued informed authorities that the suspect had long dreadlocks and was dressed in a dark pantsuit and a blue hoodie. It's also alleged, pursuant to a child, that he had white powder on his face and reeked of alcohol. Now, immediately after the incident, a parent alerted school staff that a man matching the suspect's description was hanging out near the local Walgreens. And when law enforcement approached Mr. Galligan at the drugstore, he claimed to have been assaulted and asked to be taken to the hospital. The officer did a quick background check on Mr. Galligan and found out, what a coincidence. He was a registered sex offender. He had previously been convicted in 2011 for a non-consensual grabbing, touching, or groping of another's intimate body parts, per the arrest affidavit in that case. And the suspect was arrested for a second-degree kidnapping. He is currently being held at the Arapahoe County Jail here in the great state of Colorado on a $25,000 cash or surety bond. I don't know you think good kids, this guy walking towards you, stranger danger for sure. Wonder if he'll clean himself up a little bit for his next court date on Thursday. Hey, let me give you a simple rule for life, okay? If you plan on killing your spouse, guess what? To avoid a divorce, you're probably going to prison. Take the divorce, all right? So a judge has sentenced David Lechner to life in prison without the possibility of parole for the first-degree murder of his wife, Tracy Lechner. Now, a jury also found the defendant guilty of attempted kidnapping and illegal use of a stun gun. He was sentenced to 3 years and 2 years of mandatory parole on the attempted kidnapping and stun gun charges, but those don't really matter because he's never getting out. Anyway, it is alleged, and now proven before a jury, that back on March 30th of 2023, at about 8 a.m., the sheriffs there in Arapahoe County, same place where the last story came from, deputies responded to a home to a report of a shooting. At the scene, the prosecutors said officials found Tracy Lechner dead on the garage floor next to her car. Police determined that she died from multiple gunshot wounds and her death was ruled a homicide. Now, also, according to the prosecutors, numerous neighbors heard the gunshots. Additionally, one witness reportedly saw David Lechner on top of his wife firing at her before running towards his car. Then prosecutors said the witness tried to stop David Lechner and rammed his rental truck into the side of Lechner's car. The deputies apprehended Mr. Lechner nearby. And according to the district attorney's office, David Lechner said the man shot his wife in self-defense. They also argued he only went to confront Tracy in her garage in an attempt to convince her not to go forward with the divorce. However, police learned that Mr. Lechner purchased a getaway car under a false name just days before the shooting. And the prosecutor said that he also bought a GPS tracking device, gloves, duct tape, zip ties, and a tarp. All reasonable purchases, ladies and gentlemen, right? No. And when confronting his wife, David Lechner reportedly had a taser and a handgun with him. Now, I should probably say there's nothing wrong with having a GPS tracking device. I got a couple of those little AirPod things to stick in my luggage. And when we went to Italy last year, or we were coming back through France, they lost our luggage. I could see it moving all around the Charles de Gaulle Airport. So I understand it, GPS tracking device. Gloves, maybe need to do a little gardening. Duct tape, hey, who doesn't need a little duct tape around the house, right? Give me 15 minutes and a roll of duct tape, we could take over the world. Zip ties, a little harder. Tarp, so maybe individually, not nefarious purchases. Although combined, when you just happen to also get a gun and a taser, oh, and your wife is dead, oh, and she's filed for divorce, yeah, that's right. Looks a little suspicious, doesn't it? Finally today, our dumb criminal of the day. So police were called to an apartment regarding a harassment complaint about 11:15 p.m. And when the police arrived at the apartment complex in Monroe, Louisiana, the police officer was told by the man that upon answering a knock at his door, an unknown neighbor forced her way into the apartment. The woman then, according to the victim, said, began trying to have sexual activities with the neighbor and his girlfriend. Now, while the alleged late-night rendezvous didn't result in any three-ways, a woman ended up in handcuffs. The police checked the area. They found nearby at a Circle K, a little convenience store, Shadana Ray-Shonette Heard. Shadana Ray-Shonette Heard. The male victim confirmed that that was the woman that burst into his apartment and tried to have a three-way. Needless to say, Ms. Heard was arrested early in the morning and charged with unauthorized entry of an inhabited dwelling, a felony, and a misdemeanor, including disturbing the peace, criminal damage, and resisting a police officer. Can't make that stuff up. Clearly going into somebody's home with the intent to commit a crime therein would be a problem. I guess you just don't know if somebody's going to consent to her request beforehand. So was it really a felony before she went in, or was it after when he rebuffed the neighbor's advances to participate with himself and his girlfriend? We may never know, Ms. Heard. Good luck. Anyway, you, ma'am, are the dumb criminal of the day. Congratulations, you made it. Please contact us. We'll send you a CrimeTalk mug. All right. That's all we have for you today. Thanks for watching. Remember, join us 6 p.m. Mountain Time for our live show. And remember, yes, the Constitution matters.